From DLA Piper, this is the Beyond the Curve podcast. What is the role of appellate counsel, not just as practitioners, but as storytellers and conduits for change? DLA Piper's Ilana Eisenstein, Stanley Panikowski, and Justin Sarno discuss appellate law at a time of legal, political, and societal transformation.
Hi there, everybody. My name is Justin Sarno, and I'm of counsel here at DLA Piper. I'm a certified appellate specialist in the state of California and a member of DLA's litigation and regulatory practice. I'm excited today to be joined by two of my esteemed colleagues at DLA and the respective co-chairs of the appellate advocacy practice, Ilana Eisenstein and Stan Panikowski. But before I turn it over to Ilana and Stan to introduce themselves, I wanted to set the stage briefly for today's discussion. We're going to be talking about the role of appellate counsel, not just as practitioners per se, but also as storytellers and conduits for change. Those who find themselves uniquely at the front lines of creating new inroads for both law and policy. So I could honestly think of no greater guests to participate in this discussion than Ilana and Stan, the leaders of our appellate practice. And with that, I'd like to turn it over to Ilana and Stan to introduce themselves. Ilana, over to you.
Thanks, Justin. I'm Ilana Eisenstein. I am a partner in our Philadelphia office and been co-chair of the appellate advocacy practice. And starting in January, I'm taking over as chair of the litigation practice for DLA Piper.
And I'm Stan Panikowski. I'm a partner in the San Diego office of DLA Piper. I am homeroomed in the intellectual property and technology group, even though I work on appellate and trial matters across all different subject matters. It's been a privilege to serve as the co-chair of the appellate advocacy practice with Ilana. I am sad that she is graduating to be the head of litigation, but also very excited about all of the skills and expertise that Ilana will be bringing into that position, and look forward to continuing to work with her and Justin and so many other great colleagues to grow our appellate practice.
It's honestly a pleasure to do this today. So thanks so much, both of you, for joining. The first question I have for you both is a conceptual one. Why now? Why is the appellate attorney so uniquely important and valuable in this current climate?
Justin, I think one of the main reasons for that is we are in a time of especially widespread, fast, and unpredictable legal change. Now, of course, there is always flux in the law. It reminds me of the Greek philosopher Heraclitus's statement that you can never step into a same river twice. But it does feel like the currents have become a little bit strong. They're going in directions that we cannot always predict. And I think it is for a lot of different reasons in terms of political change, societal change, changes in the composition of the courts. And those changes are triggering some trends that maybe do not fall as neatly along the ideological lines that we're all accustomed to identifying as corresponding to different legal developments. Some examples are in the area of preemption. You often find what would be typically considered conservative justices taking a view that might be more traditionally associated with, quote, liberal justices. It makes you question sometimes whether those labels, liberal and conservative, are even that useful in trying to identify these trends and then predict what may come next. Certainly in the area of regulation of large technology and social media companies, we're seeing a lot of things percolating where you might find perhaps strange partners, people who ordinarily would be clashing on a lot of the big issues of our day, finding common cause and sometimes supporting certain measures for different reasons, but ones that bring them into alignment and maybe creating some powerful forces for change. And in that type of environment, I think an appellate attorney brings three unique forms of perspective to the table. One, we take the aerial view of all of these developments. We obviously all have our own pockets of substantive expertise, but so much of what we do as appellate attorneys is trying to understand the big picture, to make sense of broader developments, discern underlying trends, and to predict the future. And sometimes it is difficult to have that perspective when you are in the day-to-day weeds of trial litigation and hand-to-hand combat on discovery and motions and various things that we all also do in our trial litigator roles. But you can step outside of that into your appellate role and perhaps see things more broadly. I think the second tool that appellate attorneys bring to the table is familiarity with the courts, usually a wide variety of courts, trying to understand the perspectives, the backgrounds, the jurisprudence of appellate judges and justices who are ultimately going to be making the key decisions that are going to shape the law. And I think having both that depth and breadth of understanding of not just the court system as an institution, but of the judges and justices as individuals will be helpful in trying to give predictions, again, not just about what might happen in a particular case, but where the law may be going generally. We try to see the law the way that everyone always said Wayne Gretzky saw the puck in hockey. Don't look to where the puck is, look to where the puck is going to be. And we try to discern that and bring the fruits of that perspective to our clients and colleagues. And then I think the third tool that an appellate attorney brings to the table is the ability to view a case, to view an issue or a legal problem from the end backward toward the beginning. And I think sometimes that perspective can inform the decisions that you might make in a case that could be a different perspective from what you would do if you're simply in the middle of that ever-changing river and trying to make the decisions in the moment to try to win the day. It can help you make decisions that might seem counterintuitive in the moment. It might lead you to raise issues that might seem unnecessary or might seem like losers in the moment, but could be valuable things to preserve and develop based on an understanding of what this case might look like a few years down the road and what may have happened in the law in the intervening time that would influence the decisions that you make today.
Ilana, what do you think about that? I mean, obviously, a wide range of perspectives and extremely insightful from Stan there. Maybe unpack that a little bit from your perspective as to the role of the appellate attorney in the current climate.
Well, thank you, Justin. I think what Stan said, I totally endorse. He really crystallized some of the roles that appellate attorneys can play in modern litigation and in the trends that are affecting our clients and litigation today. Let me apply some of that to some of the specific types of litigation that we get involved in. And one increasing trend for our clients is the rise of mass litigation, the use of MDL processes, the increasing use of class actions, not only domestically but abroad, and the fights over jurisdiction, which are recently playing out in the U.S. Supreme Court. The complexity of litigation really lends itself to the role of an appellate lawyer because you have so many moving parts. And one of those parts, which can happen not just at the end of the case, but at various punctuated places within a litigation, are cases going up to appeal, but also critical legal issues being briefed throughout the case. And I think we play a role in both facets of complex litigation, which is helping to frame the legal narrative from the very start within the trial court, recognizing that almost certainly, given the complexity and number of plaintiffs involved, those issues may go up to a court of appeals or even to the U.S. Supreme Court. So framing them from the start longitudinally in a way in a complex litigation that is best suited to victory all the way to the end of a potential Supreme Court petition or even case. Another thing that I think is driving the use of appellate attorneys is the dynamic law around how our regulators can interact with clients. So the Supreme Court has been extremely active in this realm. Cases like the West Virginia case that came out, which reinvigorated something called the major question doctrine, which suggests that maybe there are enhanced limits on regulation and regulatory authority. There's been a lot of question about how much deference agencies get and how much authority they have to do the things that they do. So that has generated an increased role for appellate attorneys in two ways. One is in defending those cases in not just the immediate defense and on the facts, but also looking at more broadly the inherent authority of the agency to even be doing what it's doing. And also thinking about opportunities to affirmatively challenge the regulations that are affecting our clients very deeply. So those are two substantive areas that I think are generated by some changes in the legal landscape that have enhanced the role of appellate attorneys for our clients.
To Stan's point about predicting the future, do you both feel that there's somewhat of an unrealistic onus that's placed on the appellate attorney to prognosticate success at an early stage, and that maybe our inherent value is that we parachute into a case and have all of the answers at our disposal? Is that the tension that you both see often in your engagements?
Well, Justin, as Yogi Berra famously said, it's tough to make predictions, especially about the future. But I think that the essence of our role as appellate attorneys is to make predictions. When you think about our chief responsibility to our clients, our chief responsibility is to persuade decision makers that the client's position is right and should be embraced in a particular case. The counseling role and the persuasion role both involve prediction at its core. When you're trying to advise a client on what to do, you are necessarily predicating that on a prediction about how other actors in the legal system will respond to a decision that your client makes. Those actors include judges. They also include opposing parties. As Ilana said, they include regulators. And then you introduce even more complexity when you're trying to make predictions about this dynamic that Ilana described, which is the interaction between regulators and the courts. And when your client is in a regulatory environment where you are trying to get regulators to take favorable action for your client, or as is often the case, trying to get regulators to refrain from taking unfavorable action against your client, you are trying not just to win the day, but trying to think about how the courts are going to react to the regulatory actions. And you need to make a prediction about how deferential you think the courts may or may not be here. And that may inform how aggressive you are in front of the agency. It may inform your willingness to try to cut a deal. It may inform whether the arguments you make are going to fundamentally attack the agency's authority and possibly engender more animosity from the agency, as opposed to simply making arguments that are going to operate within a framework of accepting the agency's authority. So we take a look at what is going on at the Supreme Court with Chevron and the rules of deference to administrative agency decisions. And we're all trying to forecast, is Chevron on its way out? Are we going to be operating in a world where there's simply no deference to agency interpretations of law? Or is the Supreme Court going to stop short of jettisoning Chevron, but fashion the satellite rules that revolve around that doctrine and apply them in ways that are much less deferential to agency authority? And that prediction will inform not just the arguments we make in litigation to lower courts and to the Supreme Court, but will also inform how we advise clients to respond to regulatory action and threats of regulatory enforcement.
Ilana, do you have a perspective on particularly that tension maybe that you become integrated in a case, and whether a client or an existing trial attorney thinks that the appellate attorney has all the answers, and how you deftly navigate that level of expectation.
So, Justin, I think there are some times when we do have all the answers, when the law is really well settled and the path is pretty clear, and we can chart a course ahead to the client that puts them on sure footing. But I will say that I think in the legal environment we find ourselves in, whether it's in state court or federal court or in the U.S. Supreme Court, there have been a lot of changes in the judiciary that I think have not only decreased the type of deference that agencies get, like we were talking about before, but also make it more unpredictable whether or not courts of appeals will exercise the same kind of deference to trial court decision-making or even fact-finding. So I think we used to be able to count on the factual record as pretty solid, for example, and the clear error standard of review as something very hard for an appellant to overcome. So if a district court found facts, you could count on them in the Court of Appeals before. And I've seen increasingly those factual questions coming into play in courts of appeals and even in the U.S. Supreme Court in ways that I think were sort of unheard of before. Maybe that's just a sign of the times that facts are up for debate more broadly in society, but I think that spills over to the Court of Appeals. So I think that makes it harder to predict with certainty how a court will react to a case. The other thing is, I think a lot of these legal doctrines are increasingly in flux that are fundamental to the case. So things like evidentiary rulings, things like the procedures that the court even uses to shepherd a case through. Again, those used to be accorded much greater deference by courts of appeals than I think they are today. So all of that, I think, enhances the uncertainty that clients face as they chart their path. I think an appellate attorney, though, again, what Stan had said about keeping abreast of those trends and where those risk factors lie can help advise clients on those risks and help mitigate those risks, as the case is even in the trial court, to bolster the record, to solidify the procedures that are used, and to make sure that those are reflected in the record that goes up on appeal in the most effective way.
Yeah, I totally agree. And maybe to your point, Ilana, I find this mechanical issue that sometimes is in play when we're in a particular litigation and a trial attorney has a methodology or a theory of their case that they feel very passionate about. And the appellate attorney is there and sees things from a different perspective. I wonder if you could each talk about that interesting but precarious balance between trying to initiate a new perspective into a litigation where the handling trial attorneys are so invested, are so in the weeds that it's difficult for them to divorce themselves from a different perspective at the late stages of a case.
Justin, I think that is certainly one of the sources of value of an appellate lawyer, where you try to learn the case while still somehow remaining astride the case rather than enmeshed into it. And therefore, you're able to offer a different perspective from what the trial lawyer has. And we find that in our practices that when we are involved in trial litigation, we are sometimes involved in trial litigation in different ways. We each have trial litigation work where we are a member of the trial team, just like our colleagues that we may be brought in to advise as appellate attorneys. There are other times where we're embedded in a trial team as the appellate eye in the sky, or we're brought in periodically to provide perspectives. And that is a different way of working with and within a trial team than when we ourselves are part of the boots on the ground. And I think that having experience in both of those roles makes it easier for us to distinguish between the type of decisions that you might be inclined to make when you've lived with a case, when you know the substantive area of law very deeply, and when you're just trying to win the day, then the decisions that you would make if you're looking at it from a longer term perspective, or maybe looking at it across a broader class of matters that the client is dealing with. And I think the good news for us in trying to navigate that tension is that typically when a trial litigator brings us in to provide an appellate perspective, they are doing so because they appreciate that they themselves, as skilled and experienced and wise as they are also constrained by their particular role and perspective. And they recognize that they will benefit from bringing in somebody who not only has the skill and the experience to advise from an appellate perspective, but is also being asked to occupy a role that preserves some of that detachment that an appellate lawyer can provide. And that's a detachment that we don't have when we ourselves are simply operating as a member of a trial team.
Yeah, one example, I had a trial recently that had proceeded almost for, 3 weeks, and I parachuted in and looked at some of the issues, and I find that there's a jurisdictional issue that hadn't been raised at any point in 7 years in the litigation. So I'm brought to analyze the circumstances, and it's like, well, are we raising a jurisdictional issue at this late stage of the litigation? And everyone's looking at one another, what are you talking about? But these are examples of, you look at things through a different perspective, you see that maybe some of the claims and issues that are being adjudicated have relevance to an administrative body who maybe is better suited to adjudicate this than a court of law. So even for the judge who's dealing with it at that point in time, wow, we're going to detonate this now, but we have to give deference to regulatory agencies. And that's the hallmark of why we enter a particular case, to see these different perspectives. But it does cause tension at some point because, well, we didn't talk about this previously. So I find it a particularly interesting role that we satisfy under the circumstances to try and extricate our clients from the throes of litigation.
I wanted to amplify something that Stan was talking about that's, I think, unique about our appellate practice, which is that I think almost all of our appellate practitioners are also trial lawyers and have significant trial experience, which isn't always the case of people who are appellate specialists as well. And I think that helps alleviate some of that tension that you were referring to, because we have been there as the person standing in front of the jury, presenting the evidence, having lived with the evidence. And I think we're especially sensitive to how to and when to present those issues to trial teams in a way that they can implement them, that they can find useful and effective, and that they view as a partnership and not just an appellate specialist swooping in with a far-off ivory tower type perspective. We know what it's like to have to balance competing concerns of trying to persuade the fact finder as well as consider the legal issues at the same time. And I think try to provide value and support rather than professorial abstract ideas.
Absolutely.
And Ilana, I think that dynamic especially comes into play with considerations of waiver. And when you're looking at it solely from the perspective of the appellate, quote unquote, specialist who's going to receive the trial court record and decision as if it were full grown, springing from the head of Zeus like Athena. When you're looking at it from that perspective, you obviously want to have every single conceivable argument at your disposal. So what is your greatest foe when you're receiving a case in that posture? Your greatest foe is waiver. And it is easy to look at what was done at the trial court and think that any issue that was waived below was somehow a deficiency in the trial lawyer's performance. And that is not always the case, because there may be very, very good tactical and strategic reasons not to raise an issue below or not to ask for a certain form of relief, because you're trying to balance so many different considerations. And even though you want to make sure you're in the best position for appeal when you get there, it remains the case that the greatest asset on appeal in almost every instance is to have won in the trial court. And sometimes if you're making decisions with too much of an eye on the next stage and simply wanting to preserve in the way that if you're a hammer, everything looks like a nail. But I think that one of the advantages of being trial litigators as well as appellate lawyers is that you understand that there may be good reasons to waive an issue, and therefore you can have a very informed conversation with a client when you make a recommendation about a decision to not pursue a certain claim, a certain argument, a certain remedy, and you can explain to the client what it is that they may be giving up down the road, but why it is actually a wise decision to go ahead and forego that. And it relates in a way to the very definition of waiver. The Federal Circuit, where I practice a lot in patent appeals and sometimes in veterans appeals, has been going out of its way more frequently to point out the difference between waiver and forfeiture. That waiver is a voluntary relinquishment of a known right, whereas forfeiture is simply a failure to raise an issue and you can't go back now and have a do-over. And I think that that distinction is not just a pedantic academic one, but I think also one that is important for us to remember in strategically advising clients. You may have really good reasons to give up voluntarily a known right. And it's obviously important to understand when you get to later stages where you might be second guessing that decision, the sound reasons you had for making that trade-off at the time. And I think analyzing questions in that way is one of the sources of value that we can bring as appellate lawyers who also ourselves have trial experience, know what it is to be under that microscope in the moment, and then under that microscope at 100x magnification when decisions are being evaluated in hindsight, especially those decisions that may not have worked out as well as you had hoped.
Yeah, I think that's a fantastic point. Please go ahead, Ilana.
So from my perspective, the appellate lawyer, especially if we're involved early in the trial stage, that our job is to make the rest of the team, the trial lawyers, and of course the client look as good as possible. And I think that we have, as a field, sometimes a reputation for Monday morning quarterbacking. Yes. And I really resist that because I see our job as more like a member of the offensive or defensive coordinating team, you know, up in the booth, helping the play callers to make those decisions as effectively as possible with the future in mind. So I see it as a partnership, but one that's really trying to enhance the performance of our team to take the record and bring it to life as effectively as possible when it does go up on appeal.
And I think in order to perform that role most effectively, we have talked about how the appellate perspective may sometimes be in constructive tension with the trial lawyer's perspective. And that interplay, even when it may create friction sometimes, has the benefit of refining the recommendations that you make to the client, refining the strategy to secure a better outcome. I think that performing that role most effectively also involves being very critical of some of your own tendencies and premises as an appellate lawyer, and making sure that you're constantly evaluating your priors and your modes of thinking that you bring to cases in light of not just what you have learned from your own experience, but in light of the changes that are occurring in the law. And I think one really good example of that is what Ilana was talking about earlier in terms of how appellate courts seem to be less willing to defer to agency and lower court fact-finding in certain instances. And I think as appellate lawyers, we certainly have a broad shared technique to try to take factual issues and tease out the legal dimensions of those factual issues and then present them to appellate courts in a way that they not just plausibly but persuasively appear to be legal issues that are reviewed de novo. And that is an important tool, but that is just a starting point. That is not the solution to every appellate problem. And I think that what we've seen in light of this trend of less deference that Ilana identified is that there will be situations where you are much better off just attacking the factual findings below head on and maybe not spending your energy and the court's attention trying to fashion it into a legal issue that may be plausible, but maybe involves a little bit of mental gymnastics, because now you may have a better shot at getting the appellate court to overturn the decision if you go right after it as a substantial evidence issue.
Well, you've hit the core of really the theme that I wanted to explore with you both today, and you did so really articulately, both of you, and that is the theme of storytelling. The theme of today's discussion. I am a huge purveyor of English literature, and in my explorations of the art of dramatic writing, I encountered an author by the name of Lajos Egri, and he wrote a work called The Art of Dramatic Writing. And he discusses in one key chapter the tension between what makes a really great piece of literature. Is it that we're more focused on the plot, the interesting circumstances that we find our characters in, or is it that it's character-driven, that a real great novel or work of fiction is great because we love the character? So conceptually, I see an analogy to appellate law in terms of what you were talking about, Stan, about what might matter more, the law or the facts, stories versus syllogisms. Do facts really ever matter more than the law, or vice versa? And I don't know that there's a right answer to that question, but I do see a viable analogy between what we are trying to focus on legally and factually in a case, and maybe having to make accommodations one way or the other to ensure that our panel really arrives at a decision that's best suited for our client. So I'm curious what you guys think about that topic.
I would love to jump in on this because I feel very strongly about the need to craft a narrative at every stage of the case, but especially in the Court of Appeals or the U.S. Supreme Court, that effectively not only tells your legal story, but your factual story, and tells them together in the most compelling fashion. And there are some circumstances where you're the appellee, so you've won below and you have the wind at your sails and you're trying to preserve your verdict. And that's one kind of story to tell about how the trial court got it all right and how there's nothing to disturb here. But especially when you're the appellant, I think you have to do more than persuade. Typically, your job is not just to persuade, but really to motivate the court.
Yeah.
Because affirmances are easy. Affirmances can be done in a not precedential opinion, can be done in a very short form. I defer to everything that happened below. That doesn't take a lot of work on the Court of Appeals part. If you want something different to happen, you need to not just say, hey, I'm right on the law. Hey, I'm right on the doctrine. You need to actually motivate those judges to write something and to craft an opinion in your favor. So to me, that's where the storytelling that is not just about the doctrinal reasons that you're right, but the force of persuasion gets to the work of writing an opinion and having them maybe work nights and weekends to write that opinion with their law clerks.
Right.
You need to think about that when you're writing the introduction to your brief, that they're going to be willing to stay up late, stay late, work the weekend to write an opinion in your favor. So that's how I think about the art of storytelling and the need for storytelling in appellate work.
I love that. I love that.
And I think, Ilana, that need to motivate generates even greater predictive challenges, because most of us do not have deep backgrounds in human psychology. Even if we did, I'm not entirely sure it would be terribly helpful in trying to predict what motivates appellate judges, as you said, not only to agree with your position, but to want to go out of their way to write an opinion that, when you're the appellant, reverses it, sends the case back to the lower tribunal for more proceedings. And it is very challenging because we don't have great analytics about what it is that motivates appellate judges. And I am not sure if it's an issue that's even susceptible of analytics. I know that the field of appellate analytics is still very nascent, and it will be interesting to see how that develops and whether that can provide another useful tool for us. But so much of the time we are going on intuition, experience, our own analysis of what judges have done in the past and how that could inform what they might do in the future. And then so often we are also trying to pull that off in an environment where we do not even know who the individuals are who are going to be deciding the case. And sometimes you do if you're at the U.S. Supreme Court, a state Supreme Court, some of the Court of Appeal districts in California where there may only be 4 judges in a division, and you have a pretty good sense of what you might get from any subset of 3 of those 4 justices. But imagine you're in a situation where you're told that you have to cook a meal for a dozen friends, and half of those friends are vegetarians and half of those friends are meat lovers. And it's not just that you have to try to cook a meal for those 12 friends. Only 3 of those friends are actually going to show up at your house for dinner. But you don't know which 3 will be coming. If you did know, you might be able to go with your vegetarian recipe. You might be able to go with your meat-intensive dish. You may try to find some happy medium that could please that entire subset, but you simply don't know who is going to be showing up for dinner. Yet, you need to buy the ingredients. Of course, the ingredients, the law and the facts are often given to you, but there are also these crucial ingredients of narrative that you were discussing, Ilana. And then you have to decide how you're going to put that together in the briefs and oftentimes in your preparation for oral argument before you know who it is that is going to be showing up. So you have to make a decision whether you are trying to put together a narrative that is going to have the broadest potential appeal to the greatest number of judges, or if you're going to go all in on one angle that some of the judges may hate, but if you get the right draw, some of them will love. And part of that, I think, requires really knowing your case and really knowing what the facts and the law are going to permit. And narrative is not a good narrative if it doesn't fit, if it doesn't resonate. So simply going in and saying, we need a story doesn't get you very far. If it's not the right story, it might even be counterproductive.
Yes.
Generally, when I write a brief, I start with the syllogism. I try to start with the bones of the argument in terms of saying, here is the law, here are the facts, and therefore, when you apply the law to the facts, here is the right result. And once I have that ironed out, I try to build the narrative around that and try to weave themes through that. And it is very challenging in many instances because, one, you are constrained by the bones themselves as to what those bones might support in terms of a narrative. And then ultimately, you're trying to tailor that narrative, not just to please yourself or your client, but to persuade a majority of judges on your eventual panel. And then so often you don't know who those judges will be, and the possibilities can just have such a broad range of people who are going to hate what you're saying if you present it this way, to those who are going to love it, and maybe even sometimes people who are going to hate what you're saying no matter how you say it. You just have to focus on tailoring it to the people who might be not just persuadable, but as Ilana said, susceptible of being motivated to rule in your favor.
Yeah, I get this question a lot from young attorneys who are interested in appellate and really want to exercise the opportunity to write appellate briefs. And the question I get is, well, how should I start this? Do you think I should start by writing the facts, or do you think I should draft a legal outline and we'll cram all the facts into the structure and anatomy of what we want to achieve legally? And it really dovetails to what you both have said. It really is a compelling narrative at every stage of the continuum. It's not a rote exercise. It's not something that can be defined in every single iteration and say, oh, well, of course, you have to do it this way every time. It's what is the compelling story that we need to achieve, and how can we do it as cogently as possible? How can we do it in a way that tells the story that the client needs to achieve, but in a way that synthesizes the legal principles in a way that can arrive at the correct objective? And it's a delicate balance, but it's also a beautiful dance at the same time. And when it comes together, obviously in great successful appeals, nothing could be better for a client. But I think it's a eternally interesting question that we're faced with when we're trying to draft new and compelling briefs and deliver new and compelling arguments to courts of appeal.
Right. And Justin, I think that another variable that adds to the complexity here, alongside what Ilana said, as to whether you're the appellant or the appellee, or sometimes you're both. And in cross appeals, you're trying to say the district court was out of its mind when it ruled this, but it was operating at the zenith of brilliance when it ruled in our favor on these issues. You not only have that axis of complexity, you also have another variable, which is, are my arguments interrelated or are they independent of each other? Do I need to prevail on all three issues in order to get the result my client needs, or do I just need to win on one? And that does not always correspond to whether you're the appellant or the appellee. Sometimes as an appellant, you get three relatively independent shots at overturning the judgment. And sometimes it's the appellee who needs to thread the needle and win all three to preserve the victory below. And I recognize that sometimes even issues that are logically independent from each other may be psychologically interrelated, especially when you're dealing with the motivation of a court to sometimes just affirm, even if you have some qualms about some aspects of the decision below. But once you have identified the degree of independence or interrelatedness of your arguments, you then turn back to the question of narrative. And if you have three independent chances, logically independent chances to win the appeal, I think sometimes you have to be a little bit wary of superimposing one unifying theme or one cohesive narrative. Because again, even if we know exactly who it is that we're trying to persuade and motivate, we still may not perfectly predict what narrative will be persuasive and motivating to that known defined group of individuals, even if a majority of judges hate what you've done with issue number 1 and number 3, you can get them on issue number 2. If you were to go in and to try to impose one narrative or theme on all 3 issues, you may then yoke your one potentially winning issue to the 2 losing issues and end up sinking your own ship in the process. Sometimes the very process of trying to impose unity will undermine the strength that your appeal has in the diversity of issues and the different ways that you might be able to win that are independent of each other and should be presented as largely independent of each other.
That's great, Stan. Ilana, on the topic of what the road ahead looks like in terms of the appellate practice and the legal landscape, and what are your views on the role of an appellate attorney as we evolve in this changing landscape?
So, Justin, I think the role of the appellate attorney is as important as ever, both as a member of the trial team and advising and charting the course of the strategy that's going to hopefully lead to success not only in front of the original fact finders and decision makers, but all the way through the course of the case. As legal strategists and partners with our legal teams and clients in developing legal strategies, in developing and counseling on their businesses. And then I think in the classic role, which is being able to take a case that was complexly litigated below to crystallize those issues for the courts above and to effectively persuade them to either preserve the victory that you've won or to overturn an adverse decision that you did not win. So I think that the appellate practice as a distinct field is here to stay, and I think it's going to continue to grow in prominence and importance in our legal profession.
Well, I can't thank you both enough, Ilana and Stan, for participating in today's discussion. I could honestly talk to you about these topics for hours, but I wanted to thank you so much for providing your experience as thought leaders at the firm. I'm personally looking forward to continuing these discussions with you both as we all continue to shape the appellate practice here at DLA. It's really been a pleasure today. Thank you so much.
Thank you, Justin.
Thank you.
Thank you for listening to DLA Piper's Beyond the Curve podcast. All information, content, and materials contained in this podcast are for general informational purposes only. This podcast is intended to be a general overview of the subjects discussed and does not create a lawyer-client relationship. Statements and opinions are those of the individual speakers and participants and do not necessarily reflect the policies or opinions of DLA Piper, LLP US. The information contained in this podcast is not and should not be used as a substitute for legal advice. No listener should act or refrain from acting with respect to any particular legal matter on the basis of this podcast without first seeking legal advice from counsel in the relevant jurisdiction. This podcast may qualify as lawyer advertising, requiring notice in some jurisdictions. Prior results do not guarantee a similar outcome. DLA Piper, LLP US accepts no responsibility for any actions taken or not taken as a result of this podcast.